Hello, everyone. Welcome to Spin Legal on Wednesday, the 14th of July, August. Why am I saying July?
You're still in July. Oh my God.
Yeah. Um, and this is Peter Giblett here with Angela Browne with me. And tonight our topic is being a witness in a court or tribunal. So if I say court, it means tribunal. If I say tribunal, it also means court. So, just bear that in mind because there's a lot of similarities when it comes to being a witness and what the rules are. Okay. So before we get into any of this, if you need to contact Invictus Legal, you can do so on 905-688-5598. Email Angela at weareinvictus.legal or myself at Peter at weareinvictus.legal. And remember, our website is https://weareinvictus.legal. Right? There we go. So, being a witness, you probably find out this because you might receive a summons. Tell
hmm
us about summonses, Angela.
Oh, a summons. Okay. A summons is where legal counsel or perhaps even a party might request to the court that the court process an order that a certain person appear for a court hearing. The summons has to be served personally on the individual concerned, and a witness fee has to be paid as well as mileage. No, the
But I
witness fee isn't enough to continue your education or make a car payment or anything like that. But it is enough it's sort of like to get you there and to pay for your parking. That's about it. Maybe a coffee during break.
I don't want to be a witness. Why would I want to be a witness?
Well, if a summons is arrived, you have to go. It's a court order. Because if you don't show up, there could be an equivalent of a bench warrant, where there could be where you fail to turn to court, and that's similar to you failing to follow a court order to
Yeah,
appear.
yeah.
I don't know how often it's enforced. I haven't seen it enforced, but it can be enforced.
It can be. No, there have been instances where people have been jailed for it.
Yep, in
That's for
criminal
sure.
court
Yeah,
particularly.
yeah.
Because
Oh,
if
yeah.
you're a crown witness and then you don't show, then the crown attorney will be, they have a tendency to start enforcing these things.
And actually, bench warrants have been, you're talking about something like, say, a $50 million fraud trial. Uh, the judge is going to issue a bench warrant for your
Right.
arrest if you
And
don't show for
there's
that.
no excuse. Like you can't say, "Oh, I had to take the dog to the vet," or "I didn't feel very well,"
Yeah,
or "I forgot."
I'm on holiday in Scarberia.
Yeah, you can't be using that excuse. This is a court order, right, when
Yeah,
you're summoned. Other times, you might want to be a witness. For example, if a friend of yours is involved in a case that you were aware of and that you saw happen or you saw part of it happen, you may want to go to court to support your friend and act as a witness in that case, and then your
I
friend will just let you know when to come to court and you're there.
I saw the car roll down the hill. I saw John Smith push it. Yeah, there
Yep.
you go. There you go. Right.
Should bring my
Okay.
watchdog the next time. I mean, that they have to report on the robbery that happened at my house. The watchdog watched it all happen.
Too bad he can't be a witness. Was
Yeah,
this a man? Woof?
exactly.
Was this a man? Woof? Was this a man? Woof?
Well, we have a parrot next door. You can also say
Okay.
a lot of things.
Here's a question that more than 5 years ago in Canada we would never have asked. Well, which is in person or online?
Yeah, this is something that's different. It only happened occasionally in uh, in Ontario, Canada, prior to the pandemic, because sometimes there's people who may be from afar and they have to give witness, video witness online or audio witness. We've had that, and I've had motions where that happened, where we can make that happen. It's like I'm not going to make somebody walk from BC all the way to Ontario so they can testify for 30 minutes.
Why not? Why why not? Hey, get them to walk, especially walk.
Get them physical fitness.
Yeah,
But that sort of thing, we were able to get that done. Hey,
yeah,
settlement conferences sometimes were able to be done by teleconference or by video. And there's certain courts, there were more and more courts trying to equip themselves. But then after the pandemic, then of course the courts were closed for a while, and then some of them started to reopen and then starting to equip themselves with technology,
yeah.
where in many instances, a lot of things are being done online. Not everything, but some things are done online. Well, we
Well,
can now have a hybrid hearing, for example. If,
yeah,
let's say, 5 witnesses are all here and they can come to the court here in St. Catharines, but we have 3 other witnesses, one in Alberta, one in Saskatchewan, and one up in Northern Ontario. We want to get these 3 witnesses so they can come to court at a certain time and they can appear on Zoom.
yeah,
Right? So we just send them the link and they can be summoned the same way and served personally, but we have to give them the Zoom link. And that can be arranged. And we've done that before too.
yeah.
And they've
Yep.
appeared.
The other question, of course, is tribunals. Most Ontario-based tribunals today are dealing with appearances and hearings in Zoom or
Zoom
other,
court.
yeah, Zoom court. So as you call it, rather like this here,
Hey, Peter.
actually,
Don't,
celebrity
don't.
square. Celebrity squares where you can turn them around like this, right? you know,
Oh.
was I making you dizzy? anyway, so um, so celebrity squares, yes, is the normal thing nowadays for tribunals. And in fact, actually, there's a number of things where this is actually a good thing because, for example, what's called in criminal court is to speak to, or provincial offences as well to speak to. So, for example, you can speak in front of a judge, where a session is being laid down for trial or moved to another date or something like
Yeah.
that. So those sort of things are easy to do. Maybe you're called for a 2 o'clock, 2 o'clock appearance. It's a 5-minute session. Do it by
Yeah.
Zoom. Get
Yeah.
it over with, and get on with your day.
We used to have
Everybody.
overfilled courtrooms in the morning just to do speak tos.
Yeah,
Where you'd go in at 9 in the morning and do a criminal court speak to.
yeah,
And then later on, I'd do a case management hearing where I'd sit down and
yeah.
then I'd work with the Crown. And those things I generally prefer to work in person, with the actual case management or Crown or what they
But
call a Crown
again here,
pre-trial.
yeah. But here we're talking about witnesses. So
Yeah,
you know,
but witnesses are, yeah,
yeah. So if you're a witness to a tribunal in Ontario, it's likely to be via Zoom,
yeah.
right?
So what will happen is a
Many
witness, we
witnesses.
send you the Zoom link. Your counsel, whoever it is calling you, will send you the Zoom link. This is where you go at 9 o'clock or 1 o'clock or whatever time they're calling you where you have to appear. And then when you go into the tribunal room, then it's sorted out as to where you go. Like
Yeah.
at the beginning of it, what they do is they do an exclusion of witnesses until you're allowed to be heard.
Well, we'll get to that.
Okay.
So what's it like to be a witness in a court, and what are the duties of a witness in a court? Right?
Well, as a witness, some people get pretty stressed out because they don't necessarily know what's expected of them. And
Yeah.
sometimes they say, well, I don't know what I can add to the whole thing because I was just there for 5 minutes.
There's another one is actually I've had is one whereby I'm hired by somebody, in this particular case a landlord, to appear at the tribunal, and he says, well, you can do it all for me. I'm going off to Sri Lanka on that day. I said, no, I can't. I can't give your evidence for you.
Yeah. All evidence has to be presented through the witness.
Yeah.
Okay? Like your counsel is not your witness.
Yeah.
Like you tell me what happened, but I didn't see that happen. I
yeah.
didn't cause it to happen or anything else.
And in
All I
certain,
know is what you told me.
yeah, and only in
And we're
certain
not allowed to
circumstances.
say anything.
Yeah. Only in certain circumstances is the legal representative allowed to say to present evidence, to present witness style evidence. And that's usually when you're talking about, you're talking about a voir dire and, sorry, not voir dire. I mean, when you're talking about a one-sided hearing, when you're giving a summary to the finder of evidence about what what happened. So you're giving that summary and why they should find your way, often because the other party didn't show up.
Yeah,
So
and
when,
usually that's presented by an affidavit that is signed by
well,
the client.
yeah, it depends on the forum, but in some courts that's done by an affidavit. In other courts that's done by, for example, if you're a landlord and tenant board, the adjudicator is going to ask for a summary of the facts,
Yeah.
right?
And the thing
So
is, the most common time then a representative can act as witness is when you're having a hearing where you're just talking about rent arrears
yeah, exactly.
and you need to prevent an L1, L9
Yeah,
form. Okay?
and
And then what you do is you summarize the L9 form, and then you can tell the board whether or not payment arrangements have been made and any
yeah,
kind of details like that. And
yeah,
that can come from your representative.
yeah,
But
and
most other
only
things, like if you're in a landlord tenant board and you're trying to kick somebody out for making too much noise or regularly paying rent late, that kind of stuff, your counsel cannot give that type of evidence.
yeah, yeah. Yeah, and exactly. So the summary of the factual information that's really not disputed, and even if the tenant were there at the time, in case of rent arrears, for example. So I'm saying to you as the adjudicator, yes, yes, Madam Chair, the tenant owes 15,169.67 between these date and this date. Blah de blah. There's certain things you can talk about like that, which even if the tenant were present, they couldn't deny said amount,
Oh,
right?
yep.
They they may, there may be some contention that the landlord says on the 1st of October 2023 he didn't pay. The tenant said, yes, I paid so much money on the 4th of October. There
Mhm.
might be some disagreement upon that, which maybe the adjudicator has to sort out. But generally speaking, those things that are spoken into fact, like rent arrears, generally spoken to, there's not really much to object to on them.
Yeah, exactly.
Yeah,
Okay. And then the other time they have a full hearing where
and
there's
and that's
witnesses
not.
or the landlord, coming in, and then the tenant would come in maybe with their witnesses. Okay, they could speak to an issue.
And
And then,
besides which, when it comes to issues like that, if I'm representing a landlord and the adjudicator has a question about certain facts, I would ask the landlord in that particular instance to, can you speak to that, right?
hmm
And that would so these are outside of the scope of what is the total amount owed, and now the landlord may well have some other issues that he might need to answer to. But so therefore, as a witness, even in a situation where the other side doesn't appear, you may still need to give evidence. And in fact, that happens, for example, in LTB, that happens often in tenant cases where landlords don't show.
yeah,
Right.
yeah.
Um, It doesn't happen very often in criminal court, because in criminal court, if the defendant isn't there, if the defendant isn't there, there's not really any trial. There might be a bench warrant issued, but there isn't a trial really
Well,
at
a
that point.
defendant, they could have the charges continued against them. They
Oh yeah,
don't show, and it could be a trial. It could be a conviction in absentia.
that's true. That's true.
Yeah, in a
Yeah,
criminal court. And the thing is, like, but the defendant must be there. They don't have to present a defense, okay? But the defendant should be there because what happens if they're represented by counsel? the counsel will go through and challenge all the evidence coming from the Crown, and the Crown can call their own witnesses, and the defense counsel can ask questions of all the witnesses and try to discredit them and try to change the narration of the story. And then they, at the end of the day, they could say the defense rests and not present a case because they can argue that the Crown had failed to meet the burden of the criminal burden, which is beyond a reasonable doubt. But in a civil court, usually a defense happens because the burden is much lower.
We'll cover that in a minute. Okay.
Yeah.
So there is also something that needs to be talked about. One is a need to weigh. In our system of law, it's possible that you called as a witness and you show up nice and early, 9 o'clock Monday morning, and you're sat in the hallway until 3:45 when you're called, and you're called for 5 minutes only, and that's it. You're done.
Oh yeah, that happened to me. I was involved with a criminal case. I was a witness at a criminal case, and I saw something happen at that time, and then I was there for 2 days in the hallway, sitting there, twiddling my thumb. And then on the third day, it went on to about 1 o'clock in the afternoon, and then they finally called me in, and my evidence and testimony and cross-examination took about an hour. And afterwards, I was allowed to sit in the gallery to watch the rest of the trial.
Yeah. Okay, so there is another thing. Okay, so moving on from there, criminal oath. So basically, this is a promise to tell the truth, the whole truth, and nothing but the truth. And importance in here is that this statement comes about because of the fact that under criminal trials, the burden of proof is actually what's called beyond a reasonable doubt. So that differs, of course, from the civil oath, whereas under the civil oath, you promise to tell the truth and that you acknowledge that you commit a criminal offense by not telling the truth. Although I've not heard of anybody being tried for perjury for not telling the truth in civil matters. It does happen.
It can happen. And you can even lay a private criminal charge. There's lots of ways that can go.
And the point is that when it comes to the civil burden, it's basically what we call balance of probabilities, which is it's more likely, i.e., 50.001%.
It's more likely than not that
more likely than
the liability would fall on this party.
Yeah, exactly. So that's why, so it works out to kind of, if you're going to quantify it, which nobody does, it could be 50.0000001%, couldn't it? But smidgen over 50%.
And that's when you really get sued, or it goes to overturned and appealed and appealed.
And no judge ever really.
Nobody asks.
Nobody asks, yeah. Okay, so here's the question. So questions are directed at witnesses by the legal representatives or the parties themselves, and sometimes by the judge or the adjudicator.
Yeah. Right? So first of all, when the witness is put on the stand, the witness is first asked questions by the representative or the party that brought them there. Okay? So if the person who called you to court is the plaintiff or the plaintiff's legal representative, you will be first asked questions by the plaintiff's legal representative or by the plaintiff. The questions that you are asked are open-ended. They will be kind of encouraging you to tell your story, what you saw, what you didn't see.
Tell me what happened on March the 1st in St. Catherine's Town Square.
Yeah, exactly. What time did you arrive? How many people were there? What was going on? Can you tell me, did you happen to come across a person named whatever? And upon what circumstances did you meet this individual? And can you describe? So these are all open-ended questions.
Okay, so the
And then
next
we go
important
through all of
question,
these questions.
the next most important question from a witness viewpoint is, how do I answer these questions?
You answer the best you can in terms of it. You have to be honest. You need to tell the truth. Okay. What do you remember happening on that day? And try to remember as much as you can about it when you're talking to the counsel that brought you there. You need to explain what you did, what you said, and what happened next, and where it's relevant with the case that the
Okay,
council has it.
so that's all very fine, but what if I don't know the answer?
If you don't know the answer, sometimes it's best to say, "I'm not sure I remember that." Hey,
What
I'm
you
not
mean
sure.
I can't make it up?
Nope. You can't make up things. You can't make up stories.
Damn. No, no,
It's
actually,
always better to say I don't know the answer or I
yeah,
don't remember. Hey,
yeah,
if they're that way, you know. And
yeah,
if somebody tries to press you and say, do you recall it? Like sometimes they might ask you a little bit about what you may recall.
yeah,
Was it raining that day or was it sunny? What was the weather that like that day? You might know the weather. So that type of thing they might ask you. So there might be some details they could get from you.
yeah, yeah, absolutely, and that actually may help you find the answer.
Yeah, exactly.
All right, so they can skirt around the issue in order to get to the answer. Okay, so there is another question there that regard. Can a witness bring documentation?
Oh yeah, they could. In general, though, if I have a witness, there is that offers or has additional documentation over and above what
Well,
the plaintiff has brought or the defendant has brought, I would separate it, but I would use that for my direct examination of the
okay,
witness.
so here's a question. So, for example, like in a criminal matter, a um, a police officer shows up and he's leafing through his book and he's like, "Oh yes, on the 1st of May, such and such happened," right?
Yeah, they're
Um,
allowed to refer to their notes.
yeah, police
Officers.
officers are allowed to refer to their notes. What about normal witnesses?
Sometimes we can ask permission if there is a specific reason they need to do that. Hey, like if they have, like say for instance, if they happen to be having to keep records as part of their job, for example, or they're an accountant or something like that for the company that you're trying to argue about that owes money, is owed money or something. The accountant can bring their books with them to provide copies of the relevant accounts to the
Why
court.
would why would the accountant bring a copy of the books and not give them to the lawyer concerned?
They would bring them to the lawyer concerned, okay? But sometimes they would need to have that when they're sitting in the witness stand.
Thank you.
And they would show that is that one and the same, what the lawyer has and what they have.
Yeah.
Okay?
Okay.
So they're
So
not looking at two sets of books.
yeah. Okay. So what you're basically saying is I can show you from my account ledger, page 52 shows X, right? And you can present, and you as the counsel will then show to me, is that the same as page 15 off of the evidence book,
Yeah, yeah.
right?
And
Is
this is
that
why when we present an evidence book, sometimes we'll have what we call the witness copy for the evidence book. All it is just the pages that the plaintiff wants to submit to the court. It can't include any arguments or any plaintiff claims or any kind of things of the original action, just particular documents.
yeah?
And the counsel would be asking only specific pages to be referenced to by the witness.
Okay, so here's a question: how does a paralegal or lawyer prepare a witness for being just that, the witness?
Sometimes a paralegal or a lawyer would give you a call if you're a witness and then talk to you about the issue that they want to call you about and ask you questions about what you remember, what you recall, and different things like that. They cannot counsel you and say, this is how you need to answer the question if you are asked this. They cannot tell you how to answer the question, They cannot give you the quote unquote correct answer to the questions. They can only say, these are the types of questions that I intend to ask you as a witness. You can answer them for me, but be understand I cannot tell you or help you when you're on the stand, and nor can I help you when you're being cross-examined. I can only I can only object if somebody asks a question that is inappropriate or too prejudicial, or there's a number of objections I could, but I cannot help you answer a question if you're asked a proper question under cross. Okay? And but we might prepare me by saying these are the types of questions that you might be asked under cross, and think to yourself about how you might answer them.
Okay, so couple of things here. We've been talking about witnesses, and you first of all opened up that one possible witness may well be somebody who came into a room and saw something happen, were there 5 minutes and then left. Um, but other witnesses might well be like, like a police officer in a criminal case who was standing on the street corner when the whole murder went down, or another one might well be the plaintiff in a plaintiff claim, right? So the actual plaintiff is going to be a major witness in their own case.
Mm-hmm. Yep. The plaintiff would be often called first, in a civil case. They would often be called first to testify about what they think happened and why they think that they have a case against the defendant or defendants. They would be asked to testify first. The counsel would ask the witness direct examination questions, as I said, the open ended type. And then after your counsel finishes asking you questions, they would turn you over to the other counsel who would then ask you cross examination questions.
Yeah.
Cross examination questions are tougher. They take they challenge the evidence that you just provided or that you might have provided in the prior
And
document exchange.
and of course the whole question about cross-examination under the way that our legal system works is that um, Angela, is Angela tells her story through her evidence, and I'm saying, uh, I can't, I basically believe that Angela's lying, right? I can't say, Angela, the evidence that you just told about being on King Street in St. Catharines last Tuesday on the at 12 a.m. That was a lie. You were never there, were you? We can't say things like that. In order to prove that you weren't there, we would have to go around the issue. For example, so on last Tuesday, did you have an appointment with your hairdresser in Western Avenue? You know,
Mhm.
yes, I did. And what time was that appointment? 11 o'clock. And how long were you there then? I was
Mhm.
there for about an hour. Maybe I chatted with them 15 minutes more. So therefore, at 12 o'clock, you could not possibly have been on King Street, at 64 King Street, to watch the murder happen, could you?
Yeah, and then you can even pull the hairdresser in, who can um, who
Yeah,
can say, yes, I met with Angela at that time, and yes, I spent time coloring your hair, and it takes me approximately an hour to color the hair, and then afterwards we chatted, then she paid, and then she left about 12:30.
yeah,
Right?
exactly.
Yeah.
So that's how you then prove that a person's a liar, because Angela says she was there, she saw it, everything
Mhm.
there, point blank. I saw Peter Giblett pull the gun out and shoot the mailman in the head, right? That kind
Mhm.
of thing, and he did it at precisely 12:01 p.m.
They'll
Right?
just hire another postal worker to deliver your CRA mail, Peter.
But anyway, so that's the way that this goes. But you can never actually say on cross-examination. Cross-examination can be tough. It should be tough because it's basically it's in our legal system. It's about actually proving. that what you've done is not good. What you said is not the truth,
Yeah,
right?
especially if you can catch number of gaps. Like in one case, there was a whole lot of things where there was a case taken against a person where there were several dates identified of various offenses. These dates were about a year ago. And then apparently there was some kind of hearing that this person reoffended somehow. And then when this person was asked, well, you have these dates, like there was a issue on this such and such a date, yes. Then there was an issue on this such and such a date, yes. And then you go, okay. And then there was a whole 11 months after that. Would you say that there were no issues? Okay. So you would kind of ask that because you're showing that there was a passage of time when there was relative compliance. Okay. And you're using that as a reason to say that why are we back in court? Yeah, that kind of thing. Okay.
Yeah. So exactly, and that's the type of reason. That's exactly why a person does cross examination, because they're basically trying to say that the witness in front of me is actually doesn't really remember what really happened on this date. The only reliable person for that you can rely upon for what happened on the 4th of July was my witness. Right.
Yeah.
I haven't presented my witness yet, but hey, it's my witness.
Yep. And they can present it.
Yeah.
Okay.
Then
Because
we
you've
present it
already
later on.
had a chat with that witness, and that witness has told you that, remember that was 4th of July and this is what happened.
Yeah.
Okay. And they talk to you. So this is how we can do it. And cross examination is a lot more difficult. As you say, they challenge what you said, they challenge any paperwork that might have been submitted to the court by yourself. And they have a right to do that because whoever that legal counsel is representing is being accused of something and is trying to defend themselves.
Yeah.
Okay? That's what we have an adversarial justice system and shows
Yeah.
that it works that way.
Yep. Exactly. Okay. So then there's actually a third stage to giving evidence, which isn't just about direct examination and cross examination. Then we've got this thing called re examination. And
Yep.
that could probably be the most confusing part for a witness.
Yeah. The witness will say, well, how come I'm being asked questions again by the counsel that brought me here? Basically, they're allowed to ask you questions after you've been cross-examined, but it has to be questions that are based on what came out in cross-examination. They
Yeah.
can't bring new questions to you or new evidence to you. It has to be something that came out of cross-examination
So,
in an attempt to rehabilitate, to restore
yeah.
credibility, whatever.
So, for example, if in the original examination you forgot to say that the shop had blue, yellow, and white lettering, logos on it, um, and that was brought up in cross examination, then you can actually ask, and what did that actually say? Oh, that said RBC Bank, right?
Hmm.
But if you if you didn't, if that same thing wasn't brought up, and you can't now ask, so what was the logo on the building?
Right,
You
right.
know,
You can
because
only deal
that
with stuff that come up in cross-examination. And many times things do, because your opposing counsel, you don't know what they're going to ask ahead of time when we go to a hearing. But after they finish cross-examining, you have a list of questions on the side when you write down in your thing there that you just want to go back to your witness to kind of re-examine them on certain questions
yeah,
so that things sometimes it's just to clarify, sometimes it is to rehabilitate. There is always a purpose for it. You can't just go through your whole. You cannot ask a new direct.
yeah, exactly. So just because that's what I was saying about, so because it was brought up in cross examination about what the store was, you can now, you forgot to ask, oh, so it was RBC Bank that you were at, or the subject about RBC never came up,
Yeah.
but now you can actually because you forgot to ask it in direct, now you can actually ask those questions
Yeah,
about that store,
yeah,
because it was brought up in
yeah,
cross-examination.
exactly.
Yeah,
Yeah. And
right.
then you just ask as much as you need to on re-examination. You don't have to go through a whole 5 hours of it.
And most of the time, I would say that most of the time, even when your witness has performed poorly in cross-examination, there are times when probably re-examination isn't going to improve the situation.
Yeah, exactly. And sometimes when they perform poorly, it really doesn't affect in terms of the key issues that you're bringing to
Yeah,
trial.
yeah, because they perform poorly on a secondary issue, right?
Mhm.
Okay, so next question for a witness is: can I stay in court after being a witness?
Absolutely. You can
Right?
sit there and watch the rest of the trial if you so choose,
You
but
can
you
come
just
back.
can't be in the trial at the beginning because that's when other people are presenting evidence. They don't want you to be influenced before you give your evidence by what other people are saying.
And
So
the other
that
thing,
after you give your evidence, you can sit in the trial and watch the rest of the proceedings.
about it is, of course, when you are waiting to give evidence at the beginning of the trial, you're not supposed to discuss your evidence with anybody else.
Yeah,
Yeah, just to put that into perspective, right? So you're supposed to sit there nicely cross-legged in the corner of the court, but in fact, actually, most people today are probably playing solitaire on their phone.
oh yes, there's too many phones, too many devices.
Yeah, right. Okay, so yeah, so essentially, once you've given your evidence, that's basically it. That's the end of your duties. That might not be the end of the trial because you may have given evidence on day one. You stay there till lunchtime. You turn up at 9 o'clock on day one. You give your evidence by 9:45. You're cross-examined by 10:30, and then you're done.
Yep,
You might not. You may choose to stay till lunchtime, let's say, or till the rest of the day, but you may not. You might not even hear the rest of the trial, and the
yep,
trial might go
exactly.
on for 6 weeks.
Yeah, I've had people who have stayed and watched the rest of the trial, even if it was a multi-day trial, because they were people who were very interested in the outcome of the case. But that doesn't happen very often. But people are welcome to do so. Like the public is welcome to attend these hearings.
Okay. Yeah, absolutely. The public is welcome to attend any hearing, anywhere in the land.
Hmm.
Whether that is in a courtroom like in St. Catherine's Court, just around the corner from us, or
You can
on
sign
a
up for a room
on a
on the
Zoom
landlord
screen.
tenant board and just do
Yeah,
it
on a
as
Zoom
an
screen like this.
observer.
Yeah,
You just can't interact with any of the parties or the adjudicator. You just
yeah.
watch.
Although that said, there have been a few protesters that I've seen that have gotten themselves banned. Yeah, you know.
Yep. Yeah, by taking pictures of the adjudicator and protesting about
Yeah.
things. Yeah, that's not good. That's not good
Okay.
because that's not respecting the tribunal. You have to respect the tribunal.
Okay. So then, anything else to add about what a witness brings to a trial?
This is a very special kind of thing because it's a very important topic because you're part of the evidence. Like in court, there's documents, you have receipts, you have contracts, you have different things that can be presented as evidence, photos, and also witness testimony. So all of these things are all part of the evidence package that each party brings to the trial and at which the judge or the adjudicator uses to make a decision out of about who would be more liable and for what, how much. So this is it's a very important role to play. And this is something, so if you're called to go to court, go to court. Summons to court, go to court. And they do have to pay you a witness allowance. And I said, it's usually, as I said, it's usually not enough to continue your education with or make your next car payment
And
with.
arguably, it also doesn't quite pay for the gas at the price that gas is today.
Yeah, it doesn't even get pay for the gas and get you to court.
Well, let's say, for example, that you're being called to St. Catherine's Court, and you're coming from Bury or somewhere north of Bury, a 2-hour drive to get here, and then you're expected to stay for a second day, and present your evidence. And then staying in the hotel costs you $300,
Mhm.
and let alone the cost of gas. And hey, I've got to fill up before I go back,
Yeah,
right?
that's
When you
happened.
add all those costs together, it doesn't necessarily recover any cost, doesn't
Yeah,
help you at all.
and that's why these Zoom hearings are good. When we can do them. Sometimes we have what they call hybrid hearings, where there's 5 people in person and 3 people on Zoom, which is good, and they're all heard subsequently.
The
And
only thing I would say about that is before you have a Zoom hearing, or at least from the perspective of a lawyer or paralegal, before you have a hearing that's going to include remote, go check out the courtroom, check that the courtroom can actually handle the remote sessions.
you actually have to make a request for that.
Yeah, well, I was going to say further, not just about making a request. Remember, we
You
turned
might
out.
have to make a request to go to a courtroom that has audio
Yeah,
visual.
I was going
Not
to say.
all of them are equipped.
Yeah,
Still, despite the
yeah.
fact that we just gone through a pandemic.
Yeah, and in fact, actually, we went to a court. You remember, we went to a court a couple of years back, where we turned up and we told the court we have remote witnesses, and the court clerk on at the time said, "What? I don't have Zoom court. I've got no televisions in here. We've got no facilities in this courthouse for remote attendance."
Even though we'd let them know that we
Even
wanted to
though
have
we had
this
told
one
the court
attend by Zoom.
months in advance. Yeah,
So what we did is we took everybody that we were able to do with in person and had that, and then we had the Zoom call
that's
later
why I
on.
said go check it out in advance.
Yeah, exactly. And this is very, very important for that kind of thing. And the
Yeah,
other thing too is the actual expert witnesses. Sometimes you'll hear about it, like when you watch TV and you hear about all these forensic people, forensic accountants, coroners, specific people, fraud examiners, and then other people, engineers, and different people like that who are called and to give expert witnesses on a thing. We do that too in criminal court and in civil court. We sometimes call upon an expert. An expert is actually compensated for their time. You can't just call them and pay them the regular $50 a day or whatever it is to come to court. And although somebody was saying this about bringing the premier on one of those landlord tenant hearings, I showed him how to. but but the interesting thing is when you have an expert witness is that you contact them ahead of time, ask them to do a study, ask them to do some research, go on the site that's the issue of the trial or whatever, do
yeah,
some tests or whatever, and provide a report. And this report has to be provided to court, and if you're bringing the expert in, they have to be, the parties have to be notified that the expert is coming in. The expert also has to be paid to come in and testify. So whatever amount of hours or whatever they're expected to come into court, they get paid. Okay? And they usually have a rate that they charge. Because there are people all over, like who are in special fields, that they will put themselves out as expert witnesses in particular circumstances.
yeah. Okay, so I think we've gone through quite a bit about witnesses today, and I think the the upshot really is to be a witness. You've got to be prepared. Right? You've got to know what happened, refresh your memory about what happened, go through any notes you may well have
Mhm.
taken. And, if you're being called by, if you're being called by John Smith, who's represented here, who whose representative is Mary Jones, then ask Mary, what may I expect?
Yeah, ask Mary, what kinds of questions are you going to ask me?
Yeah.
And after you've gone through that, now, and the other side starts cross-examining me, what kinds of questions might I be asked in cross-examination? We can't predict what questions they would ask in cross-examination, but over time as we practice, we kind of get used to other people's practice styles. So we kind of help you a little bit by giving some potential questions that could be raised.
The other thing is I often tell people that if you don't know what the answer is, just say I don't know.
Yeah, exactly.
Right? There's there's many ways, for example, saying I don't know, but I can go find it in the rent ledger is not necessarily going to help, because if the rent ledger hasn't been put up in evidence,
What rent ledger?
help. Yeah. Yeah.
I've been known to say, "Where's the rent ledger in the evidence
Yeah,
package?"
exactly. Um, so, you know, you can you can refer to the rent ledger and you can say yes, they owe $162.96 on July the 2nd,
Hmm.
right? Sure, you can say things like that,
Yeah.
but if it's not actually in evidence, then you can't go off and say, hey, I'll go find it in the rent ledger.
Hmm. Exactly.
Right? The evidence must be physically available to the court or to the tribunal, in order for the decision maker to actually make their decision.
Yeah.
Because sure, you as a witness can be saying, yes, they owe me this amount of money in rent, and the adjudicator can actually look at you and go, Angela lady, she's a beady eyed, person. I don't like the look of her. No. Yeah, I accept that 15 cents is owed.
Yeah, an order for 15 cents.
You know
And
where
try to enforce it.
you know where I'm going with that, right?
Yeah, exactly. Try to
Exactly.
enforce that much.
Okay. So I hope you've had fun, just the way we've had fun here. And just want to say to everybody that if you need to contact Invictus Legal, you can do so on 905-688-5598. You can email Angela at weareinvictus.legal, or myself at Peter at weareinvictus.legal, or visit our website at https weareinvictus.legal. There we go.
Yeah.
And
And sooner or later, we are going to put us on the. We're going to be putting us on the Spin Legal website on Facebook. We're not able to coincide live broadcasts on Spin Legal, but we're eventually going to be moving all of our Spin Legal episodes to the Facebook page. It's just that it's going to take us a little while, about a couple of weeks or so, before we can do that.
yeah. And just for everybody's sake, I put down in the comments how you can contact us, right? So everybody can know.
Yeah.
And Angela, this is always your favorite part of the show.
Yep. So what you've heard today on Spin Legal or any of our previous episodes is not legal advice. If you need legal advice, please contact a paralegal or a lawyer. We'd certainly like you to come to us, but if you have somebody in mind, it's go to a paralegal or a lawyer, because what you hear on Spin Legal or any other program where they're doing a podcast of this type, this is not legal advice.
Yep. And I think that that kind of brings us to an end of the show about witnesses and what you bring as a witness. And remember, due to our legal system, the way it operates, everything depends upon witnesses. And you can't just say to your representative, "Hey, you can tell my story for me." It doesn't happen that
Mhm.
way.
Or you can't just write it down and tell them that, oh, give this to the judge. No, you
Yeah,
can't.
you can't.
These things have to be talked in person because you have to be available for cross examination.
Yeah. And the whole point is that's the whole point is that cross-examination and the other side's ability to tell the story is all about, well, do I believe, I have one witness on this hand who's telling me these five things occurred, another witness on this hand who's telling me only three things occurred. Which one do I believe?
Yeah.
Right? Which one seemed the most likely, that I'm going to believe?
Mm.
Right? Who was the most positive? That's essentially the issues about witness. We do it that way in order that the adjudicators actually deal with that in order that we actually give, that's how we decide things. Anyway, we'll leave it at that and go from there. And as I said, we can, if you need, this is the information about contacting us, and have a great week, and we'll see you again next week. Okay. All
Okay.
right.
And if you have any ideas for topics you'd like us to discuss, just post it in our comments or send an email.
Thank you. Bye.
But